This is Hubwonk. I'm Joe Selvaggi. Welcome to Hubwonk, a podcast of Pioneer Institute, a think tank in Boston. Despite the efficacy of COVID-19 vaccines in increasing disease resistance and in reducing incidence of severe symptoms and death, many Americans have decided to decline to be vaccinated. As an effort to increase vaccination rates, and in the absence of legislative action from the US Congress, President Biden called for a federal vaccine mandate, first for nearly 100 million American workers through the Occupational Health and Safety Administration, or OSHA, and also through the Centers for Medicare and Medicaid Services, or CMS. The resistance to these federal mandates has culminated in legal challenges, ending with the Supreme Court determining the OSHA mandate unconstitutional, but also allowing the CMS mandate to take effect. What can these different outcomes of these two cases tell us about the competing powers amongst our branches of government? And how does it reveal the differing views of the Constitution itself, held by the justices on the Supreme Court? My guest today is Ilya Shapiro, Vice President of Cato Institute, Director of the Robert A. Levy Center for Constitutional Studies, and publisher of the Cato Supreme Court Review. Mr. Shapiro has written extensively about the Supreme Court, including his recent book, Supreme Disorder, and will share with us his views on the merits of these two cases and what the decisions can tell us about the views of the 9 sitting justices. When I return, I'll be joined by constitutional scholar Ilya Shapiro. Okay, we're back. This is Hubwonk. I'm Joe Selvaggi, and I'm now joined by Vice President of Cato Institute and constitutional scholar Ilya Shapiro. Welcome back to Hubwonk, Ilya.
Good to be with you. Happy New Year.
Thank you. All right, we're going to be talking about the Supreme Court recent rulings on the OSHA and the CMS vaccine mandates, about which you've written a great deal about these cases. But before we get into constitutional law, I want to offer our listeners a little bit of a civics lesson. I think it might arguably be a high school level civics lessons, but I think it's important for background about understanding why there might be tension between an executive branch ruling and the Constitution. So let's start at the beginning. We know that we have a Congress to make laws and we have an executive branch to implement the laws. How do these concepts play out when we're talking about something like a vaccine mandate?
Right. Well, throughout the pandemic, there's obviously been lots of innovative, novel public policies that we haven't had to contemplate. Most of the action that's reached the Supreme Court, at least until this month, has involved states' policies with claims based on individual rights. They're restricting my freedom to get together in a church and worship. They're closing my gun store, hurting my Second Amendment rights. Economic liberty claims. That is different because state power, the nature of state power is different from this most recent argument and decision by the Supreme Court regarding federal mandates, whether we're talking about the OSHA private sector business mandate or CMS, Health and Human Services, requirements for workers of facilities that receive federal Medicare or Medicaid funds, or others that have not reached the Supreme Court, like federal contractors or federal employees. The federal government gets its powers from the Constitution, from the U.S. Constitution, which enumerates the items that the federal lawmaking authority can affect. Things like raising armies or coining money or regulating interstate commerce. A lot of federal programs are based on that latter. State powers, on the other hand, are kind of background inherent powers of a sovereign, what's referred to as the police power, which doesn't refer necessarily to the cop on the beat or the old band featuring Sting, but rather a general authority to legislate or regulate for the public health, safety, welfare, and morals as traditionally defined. And so typically with various state regulations during the pandemic, the claims are not that the state is going beyond its power. Sometimes there are claims under state constitutional law that the governor or health executive is overstepping his or her bounds under state law. But these are generally claims that the government is violating various kinds of individual rights. And the most important case in the Supreme Court that gets talked about a lot in this context is from 1905 during the smallpox epidemic in the United States and throughout the world. A case called Jacobson versus Massachusetts, where that state required people to get vaccinated or pay a $5 fine, which is about $150 in today's money, and the Supreme Court okayed that. But again, that's a state mandate. What we've been dealing with lately with the Biden administration's federal mandates, most notably the Osha one that affects, I think it's 84 million people. The question is, does the federal government have the power to impose that? And does Osha, as a regulator of workplace safety and conditions, does it have the power to promulgate that kind of requirement on employers?
So let's talk about that. We've got an agency, an executive agency that has in its name health and safety. It's been given the task of keeping workers safe. How much latitude is enjoyed by an executive agency? Naturally, it's an agency is created by Congress. It's given powers by Congress, but how much latitude does it have within those powers?
Well, ultimately, the Supreme Court ruled, to put kind of the bottom line up front, the Supreme Court ruled, and again, this is an emergency procedural case that hasn't been fully litigated on the merits, but I think the writing is on the wall if it ever returns to the Supreme Court. What the court majority, it was a 6-3 decision, said was that the risk from COVID transmission is not a workplace hazard. It's a general hazard of life in America, in the world, during a pandemic. And so, in effect, if OSHA had the power to regulate with respect to COVID, require vaccinations, then there's no limit on what it could do. And at the very least, Congress would have had to specify explicitly that it was giving OSHA the power to impose these kinds of mandates. And the only clear statement we have from Congress is a resolution of disapproval by the Senate that was passed in December after OSHA promulgated its emergency rule. So, this is, even if OSHA is constitutional, setting aside that kind of deeper constitutional debate about whether regulating workplace conditions is a proper regulation of interstate commerce or things that affect interstate commerce, setting that aside, the court found, and I agree with this, that what OSHA was doing here goes beyond regulating workplace conditions.
So I just want to be clear on this, and again, I don't want to split hairs, but these were emergency orders. But in theory, if Congress had given them the right to explicitly mandate vaccines, then this would not have been an issue?
It would have been a different sort of case. So what the Supreme Court decided was based on statutory law, that the OSHA has powers to address grave dangers in the workplace when they're necessary to do so. That's the emergency standard. And OSHA has not a very good track record with these emergency, what are called ETS, emergency temporary standards. It has until this one, so this is the 10th time it's ever implemented an emergency standard. Of the previous 9, 6 were challenged in court, and only 1 was fully upheld. So courts have been wary of giving OSHA that kind of emergency standards. Maybe if it had put in the rule through a normal process of notice and comment, this now gets into administrative law, and something that Justice Amy Coney Barrett said during the oral argument, that if it had gone through normal process, maybe there would have been more deference owed or what have you. But regardless, if OSHA was, let's say, if Congress had given it the power, then there wouldn't have been that statutory claim that it was going beyond its authority. Instead, it would just be the constitutional argument over whether Congress even has that power to give an executive agency, or whether it's a violation of what lawyers call the non-delegation doctrine, that is, delegating away lawmaking authority, or for that matter, a question of whether this kind of regulation would be improper, that goes beyond federal authority under the Interstate Commerce Clause.
So we're talking about either going the path of an emergency, which doesn't have a good track record in the courts, I guess largely based on the fact it wants to ensure that OSHA and the executive branch don't have unlimited power, unchecked power. Again, I don't want to torture this question, but I want to get to the concept of major questions, which is that if the Congress gives broad, let's say vague authority, one can either interpret that as saying it's inclusive, meaning or enumerated, I guess would be the right term, or it's vague enough to allow anything to happen. Was that an issue in this particular case?
Absolutely. Several justices during oral argument 2 Fridays ago now raised the major questions doctrine, which holds that Congress does not lightly give authority to executive agencies over major questions. What's a major question? Well, something worth significant amount of money or a major change that affects a lot of people's lives. There have been various there's precedents about what's a major question. Certainly, a vaccination requirement that affects 84 million people qualifies. There's no doubt about that. And this goes back to what the late Justice Scalia more than 20 years ago referred to as the principle that colorfully that we don't hide elephants in mouse holes. That is, if you're going to assert, if an administrative agency is going to assert such sweeping authority, there better be explicit authorization by Congress. You can't base that sweeping authority on vague or ancillary statutory provisions, or what Justice Kavanaugh during oral argument called a cryptic provision. So it has to be explicit. It has to be clear. Otherwise, courts will not assume that the agency has that kind of power.
I see. So, in other words, a vaccine that affects 84 million people is the elephant. We can't find that in the vagaries of the OSHA's charter, I suppose. I want to go back to a concept you had.
Say, both in the oral argument and the ultimate opinion, the court left open the idea that OSHA could regulate more narrowly. Let's say there are workplaces where people have to work closely together and it can't be well ventilated or something like that. You could imagine very targeted sorts of regulation about COVID that are specific to that kind of workplace. I think, given the standard that the court, how it wrote its opinion, something like that might pass muster.
But I want to get back to a more fundamental concept. There was a lot of debate about what you referenced earlier as a police power. Let's assume we have a mandate from OSHA, and now it's out there. How does the federal government enforce such a mandate? Again, police power reside with the state. How does that work?
Well, OSHA has health and safety inspectors that enforce all sorts of regulation, what kinds of protective equipment you have to have, if it's a dangerous workplace, the amount of rest that workers have to have, truckers say, although the Department of Transportation has a say in that as well. They levy fines. Workplaces are, I believe, under the new rule, are supposed to submit their safety plans, submit their certifications, I guess, with this new rule that their workforce is vaccinated or is employing the alternative, which is to produce a weekly negative COVID test on the employee's dime and time. The employer does not have to provide them with that. And so the OSHA bureaucrats will be reviewing those sorts of things. It's not like instantly when this goes to effect, or had it gone into effect, because of course now it's stayed by the Supreme Court, that the very next day anyone who's in violation will be have a SWAT team sent on them. But it's basically the same way that OSHA would enforce any other kind of regulations. There are inspectors, there's paperwork to submit that people then review, and that's how they proceed. And there are fines. I think it's up to $14,000 a day or per employee. I think that I saw. So pretty significant fines for noncompliance.
So I want to develop the idea that you talked about. Certain aspects of the mandate are too broad, namely that it's all workplaces. I can imagine we would differentiate between meatpacking, which seems to be the scenario whereby we can imagine it being a useful mandate, versus a lifeguard who's out there on a chair all by himself, unlikely to get COVID while at work. That would be an example of perhaps why they had a problem with how vague it was. Say more about the way it could have been crafted, perhaps a mandate that could have been crafted that might have gotten the blessing of 9 justices.
Right. There are exemptions for purely outdoor workers. although it's very hard to meet that exemption. So you'd think, oh, so lifeguards, like your example, or landscapers or something like that. But it turns out not very many of those qualify based on how the standards are written. And meanwhile, not all indoor workers, conversely, are covered. And for that matter, there's a relatively arbitrary 100 employee trigger. So if your business has 99 employees, you are not subject to this mandate, no matter how crammed in with whatever ventilation there might be that you might have. Conversely, if you're 100 or 101 employees and they're scattered throughout the country working remotely in their own homes, you are covered. So that sort of arbitrariness and lack of tailoring while imposing this kind of burden, I think, is something that the court looked at. And they did hint, the justice, it was a relatively short opinion because they produced it, I think, in 4 or 5 days after the argument. But they did hint on the sorts of things that if OSHA now, rather than pursuing the litigation, which is ongoing in the lower courts, and for that matter, I just submitted with a couple of colleagues a regulatory comment because the period only closes tomorrow. You can give comment for OSHA trying to finalize the rule, not to transform it from an emergency to a regular rule. So we just submitted that yesterday. Still taking comments, still proceeding with on the understanding that it wants to implement it long term. If it abandons that, goes back to the well and recrafts the rule such that it covers, certain tight spaces or has exemptions for employees working remotely, or purely outside, relaxes the definition of, makes it more common sense definition of what working outside means. That could indeed survive statutory muster, because at that point, OSHA is indeed treating different workplaces differently and treating unique risks from an infectious disease differently in certain workplaces. The same way that OSHA requires protective equipment, ventilators, headgear of various kinds, masks, and so forth, where they're infectious or other kind of agents, and doesn't just broadly require them for every type of employer.
Does now we keep referring to this as a vaccine mandate, but it was a vaccine or test and I guess mask mandate. Does that strengthen the argument? Meaning, look, we're not forcing you to vaccinate. We are forcing you to either vaccinate or test. Does that make it more palatable, let's say, for Supreme Court muster?
The lower court, the Sixth Circuit, that looked at this before the Supreme Court did. There was a dissent from Judge John Bush, who pointed out why it actually is a vaccine mandate, that the alternative is sort of ephemeral or so burdensome as to effectively act as coercion towards getting people to vaccinate in the first place. That you have to do it weekly, you have to pay for it yourself. OSHA is not providing that. You have to take your own time to do it. And I think there have been quotes from the Secretary of Health and Human Services, Javier Becerra, President Biden, when he announced the mandate back in September before the rule was made explicit and put on paper, said that we've lost our patience. So it's clearly all targeted to get people to vaccinate. The alternative is not really it's too burdensome. Maybe if it was truly a testing alternative, such that the government provided the tests and they were available at the workplace or something like that, maybe it would be evaluated somewhat differently.
So it's perceived to be coercive, forcing people to vaccinate, not having a good faith allowance for those who prefer to test and rather than vaccinate. I want to move on then to the meat of your expertise in analyzing and understanding the court and its members. We had a 6-3 ruling, as you mentioned, but it wasn't just 6 anonymous judges and justices and 3 dissenters. There were, as I saw it, 3 rulings. There was the per curiam, which is the majority, which we don't know who wrote. Then there were the concurring opinion justices, and there was the dissent. Can you break down the 3, 3, and 3 and tell us why each decided the way they did?
Sure. So the per curiam, as you said, this is when there's an emergency or some sort of unusual procedural posture. It's often that the court decides it. It's not that they are ashamed to reveal who wrote it. It's just kind of the process that they generally follow with these kinds of procedural postures. But that was to use the shorthand, it was the 6 Republican-appointed justices. So Chief Justice Roberts, Justice Thomas, Alito, Kavanaugh, Gorsuch, and Barrett. And so the three in dissent were Justices Breyer, Sotomayor, and Kagan. We've covered the majority opinion, I think, in good depth. The concurring opinion, it was written by Justice Gorsuch with Thomas and Alito joining, went more into the major questions doctrine and the issue of who decides that it shouldn't be. It should be the people's representatives. It shouldn't be judges. It shouldn't be the administrative agencies that after all, we're not elected. And so that kind of plays into what Gorsuch in other contexts has talked about, the hydraulic pressures on the checks and balances of our constitutional order, and making sure that that there is political accountability. It's not just an executive agency, kind of the fourth branch of government, as some have called it, beyond the original three that we learned about in grade school. That's taking authority that it doesn't have. In dissent, it was they specified, Breyer, Sotomayor, and Kagan did, that they were all three of them were co-authors of it. They talked about the severity of the pandemic, and that OSHA specifically was regulating dangers in the workplace. It wasn't regulating people going to optional activities like a baseball game or social get-togethers or what have you. Working is very important. Everyone essentially needs to work to be able to live, and so it's within OSHA's power to control that workplace. That is their argument.
So in reading
333, I should add, Joe, maybe comes in more in the companion. I mean, there could be a reason why Barrett, Kavanaugh, and Roberts didn't join the supplemental major questions argument, unlike other cases where the more conservative justices write separately. I don't think it was that concurrence was necessarily more, reaching for more. It was kind of just describing more of the doctrine. But you see more of a split in the companion case, which we haven't talked about, but the mandate on healthcare workers in providers that receive federal funding. That's a different type of constitutional and statutory question, because it's the government attaching conditions onto its own funding. It's not, what are the powers of a regulatory agency so much. And that was a 5-4 decision to allow the mandate to continue, with Roberts and Kavanaugh joining the more liberal justices in the majority. So you saw some splits there.
So I want to get to the CMS case and compare it with this OSHA case, but I want to give a proper acknowledgement of the dissent. It was in questions that Judge Sotomayor compared, let's say, a coworker shedding virus with a malfunctioning machine shedding sparks. How is it different? If I can get hurt at work, either from sparks or from virus, why is it different? Again, acknowledging the dissent's argument, why is it different if my danger is a virus at work than a crane falling on my head?
Well, one thing is that people have rights and machines don't. So the court is dealing with some rights balancing as well. But also, I think it really comes back to the fact that the risk of the virus is global rather than workplace specific. So if you leave the workplace, you're no longer subject to these sparks. But if you leave the workplace, you are subject to the risk of gaining COVID. And a vaccine, after all, is not workplace specific. It's not that you get a shot every day at your workplace and then it goes away or what have you. You can't undo it. It's something that's with you forever. It's I guess you could liken it to having to wear a hazmat suit all the live long day, even not on the workplace.
Okay, let's segue to the CMS case, which is fundamentally different and it came down differently, right? The Supreme Court allowed it the mandate to continue. You're talking about a different, OSHA is different. We're talking about private companies and workers in those private companies. CMS is a different animal, which they're talking about their own sort of members. Describe for our listeners why CMS is different than OSHA fundamentally.
so much that OSHA is a different agency than CMS is that this is not CMS regulating the workplace per se, but and not even saying that all healthcare providers have to do certain things. It's saying that anyone who accepts federal Medicare or Medicaid funds has to comply with certain conditions. And when providers sign up for those funds, they agree, it's part of their contract, that OSHA can change the terms for the benefit of public health and safety. There's disagreement between the justices, between the majority and dissent in this case, on whether it's clear that a vaccination mandate can be part of that. The dissent accuses the majority of kind of cobbling together disparate provisions that that CMS has used to change funding conditions over the years to justify this novel type of mandate. But nevertheless, this is almost a contract case in the sense of changing the terms of a contract, whether that's allowed based on what you already agreed to, and the strings that attach federal funding that at the end of the day, the provider does not have to, if it doesn't like, doesn't have to accept that federal funding. It's different than OSHA regulating every workplace, regardless of a connection to a federal program.
So it's connected to the fact that the federal government funds these organizations and therefore has certain prerogatives. I'll just relate it to, as an aside, as my fellow veterans in our audience will know, the Department of Defense had always made it clear that it was not our prerogative to refuse a vaccine. My personal experience is I was dropped into all kinds of places around the world. They consistently lost my shot card, so I probably have enough vaccines in me for a small village. But we're not saying that members of CMS who sort of, I guess, accept the terms of federal money, they have more prerogatives or rights than a soldier does. What constrains what CMS could do here? Is there anything? I know, again, in the military, there is no constraint. They can take your life, but CMS is a little different animal.
Yeah, and what you raise is yet another different type of mandate. That is the federal government acting as an employer, whether of servicemen or federal workers of other kinds. A clerk at the IRS, say, or for that matter, the White House counsel himself. The power of the government as an employer is different than when it's regulating other entities, and different again with contractors, the rules of government contracting, and different again with CMS, where again it's the strings attached to funding. And you're right, they can't retroactively add any rules. In fact, in the constitutional challenge to Obamacare 10 years ago, we all know about the individual mandate part that John Roberts considered to be an exercise of the taxing power. But we forget that the court at the same time, by a 7-2 vote, invalidated the forced expansion of Medicaid, saying that was coercive. That was adding new conditions. That is, if you want to keep getting Medicaid funds, you have to agree to the Obamacare expansion. That was changing the terms of the game after the fact. So there are limits on the types of strings and how they can be added and when to CMS funding. That, in fact, is one of the disagreements between the majority and the dissent in this case.
I don't know if I can draw this link, but tell me if this follows. From my reading, it seems to me that the court, in its different ruling, OSHA, it stayed the mandate, and CMS it did not. Did it point to history, meaning that OSHA really hadn't had these prerogatives even in emergencies in the past, and so it won't have it now? And in the past, CMS has had those sort of powers, and therefore the court didn't want to take them away. Is this sort of from my sort of layman's view, a validation of more or less a status quo going forward?
Well, I think everyone agrees that vaccine mandate is unique and unprecedented at the federal level because pandemics are unprecedented. The last time we had a major one, the federal government was so large. This is before the New Deal, effectively. I mean, there's some things around polio in the 50s, but a little bit different. And so the precedent that we're talking about is CMS changing rules on the fly and having more flexibility to do so as developments in health and safety progress and what have you. And so there is that argument between the majority and dissent of whether adding this rule and this requirement is like some of the additions of requirements in the past, or whether it's qualitatively different because either it affects so many people or involves injection into the body rather than wearing some protective gear or what have you. That's certainly one of the places where the battle is joined over this. Whereas in the Osha case, it's not whether Osha has ever done anything like this. It's a debate over whether this is truly a regulation of the workplace or something broader with no limiting principle.
I want to go right into your, as we get close to the end of our show, into your deep expertise in understanding the members of the court, and help us understand why there was a 6-3 ruling in favor of staying the mandate and a 5-4 ruling on allowing a mandate. Same 9 people. There was some shifting going on. What does this tell us about the court's makeup? And I'd also like you to sort of address criticisms that the court is perceived or is partisan in its decision making. What do you say to explain either that you see it as either partisan or that they are ideologically or intellectually consistent through these 2 rulings?
Well, first of all, there are different legal issues, and so justices can certainly disagree. So the difference is that Roberts and Kavanaugh, who were in the majority in staying the Osha mandate, were also in the majority in allowing the CMS mandate to be enforced. Roberts and Kavanaugh tend to be more pragmatic. I think they don't see probably the CMS mandate as an expansion of its power or kind of this threatening an unlimited federal or administrative agency power. They see it as more discrete and tied to the particulars of the Medicare and Medicaid statutes. I think that's how you can explain that thing. And in general, the 6 Republican-appointed justices, I think there's a lot more different among them, certainly in the outcome and in the votes in certain cases, but also how they approach their craft intellectually. The theories they apply. Roberts is minimalist and incrementalist, more pragmatic. Kavanaugh, while very much skeptical of administrative power, also doesn't want to make waves, doesn't want to, wants to adhere to stare decisis, that is, sometimes maintaining erroneous precedent because it would be too disruptive to change it. Thomas, on the other hand, a staunch originalist and also doesn't care much, if at all, about stare decisis. Alito is kind of more law and order oriented, defers more to law enforcement in certain types of agencies and not others. Gorsuch is the most libertarian of the bunch, if you will, also natural law oriented. I mean, anyway, we can cycle through these things. I don't think any justice, left, right, whichever president appointed them, is acting as a partisan. I think they certainly have different ideological views, different jurisprudential methods and modes. And that affects the outcome in different types of cases.
So accusations that the court is partisan or driven by politics, you don't see any sort of sign of that. And frankly, regardless of the party of the administration, they probably would have ruled in the same way if there was a different person in the White House directing Osha.
I think that's right. That on your latter point, yeah, I think it was they were evaluating the policy, not the president who was promulgating it. This court, including the most recent nominees, voted frequently against Donald Trump, even the ones that he nominated himself. Less occurrence of that, I think, from the justices on the left. I had an op-ed in USA Today, I think it was 3 years ago, when Sheldon Whitehouse, who continues to assail the Roberts 5, now I guess it would be the 6, for being partisans and for voting in lockstep, and it turns out it's the Ginsburg 4, now would be, I guess, the Breyer 3, who are much more together statistically speaking, which again is not to accuse them of being partisans or being result oriented. That's just the way the different methodologies work. Fundamentally, what we face, and this is you can apply this insight to a host of debates over the law or the Supreme Court or our institutions, is that you have divergent interpretive theories mapping onto partisan preference at a time when the parties are more ideologically polarized and sordid than they've been since at last the Civil War. So what looks like partisan fights is really evidence of a different kind of dynamic that certainly it plays itself out whenever there's a Supreme Court vacancy.
Again, now we're wrapping up. I want to talk about the theme in your most recent book on the Supreme Court, where you say effectively, when we're deciding what's right and wrong, but rather who decides, really it ought to be Congress that decides. And these fights in the court are a reflection of broader failures to resolve questions in Congress. But I want to talk about the executive branch. Just the last question. The president seemed to have known that the Osha mandate was likely to be unconstitutional. You may not agree with that, but it seems that they needed to have a quote unquote workaround. Is there political incentive to, in a sense, have an executive order, knowing full well that it's likely to be struck down, merely to, in a sense, score points or give the people what they want? In other words, we want a king, we don't want a Congress. Is all of this, in a sense, an act whereby we know we're not going to have success in the courts, but it's worth it anyway?
That's kind of a cynical take to have. I think there is some of that going on. Same thing with the CDC's eviction moratorium last summer that the Supreme Court blocked, that perhaps the president, the administration wants to have these things in place for as long as they can get away with them until the courts block them. I think that's a dereliction of duty, a violation of your oath. If you think that it's going to be, that it's not constitutional, and yet you do it regardless. But it's certainly part and parcel of a long time trend. This did not originate with Joe Biden. Elena Kagan, when she was a professor, wrote a seminal law review article more than 20 years ago called Presidential Administration. And it was really presaging this era of the pen and the phone, as was talked about under President Obama, or the idea that Congress is gridlocked or dysfunctional. We can put a pin in whether it is dysfunctional or not. There's different dynamics going on there. But regardless, Congress is not acting, it's not legislating, and therefore the executive has to act to do the people's business. That's not the way our system is supposed to function. It's not healthy. But that's ultimately why a lot of the biggest political controversies in American life are ultimately decided in the courts and by the Supreme Court, because, of course, Congress isn't deciding them, and everything's thrown into the executive, and then there's a lawsuit, and the courts have to decide. It's not a healthy dynamic, but again, it's not necessarily something that just dropped into us during the pandemic or under the current administration.
So we started with a civics lesson, and we've come full circle around to another civics lesson. I appreciate your time with us back on Hubwonk. Ilya, you are a fund of information, and I think our listeners learned a lot today.
My pleasure. Take care, Joe.
This has been another episode of Hubwonk, a podcast of Pioneer Institute, a think tank in Boston. If you enjoyed today's episode, there are several ways to support the show. It would be easier for you and better for us if you subscribe to Hubwonk on your iTunes podcatcher. If you'd like to help make it easier for others to find Hubwonk, it would be great if you offer a 5-star rating or a favorable review. If you have ideas or comments or suggestions about future episode topics, you're welcome to email me at hubwonk@pioneerinstitute.org. Please join me next week for a new episode of Hubwonk.